Good evening, everyone. I am here to talk a little bit about the California Supreme Court's decision to disbar John Eastman, one of Trump's lawyers, in the election disputes from 2020. What Eastman has said in the media is that he had a First Amendment right to make statements about the election, and that California is trying to violate his rights by doing so, by punishing him. Where I don't agree with his claims is that he is being disbarred principally for making false statements in pleadings to courts, and he's charged specifically with violating a provision of California law. Let's look at that provision. It is provision 6068 of the Business and Professions Code, Article 4, Admission to the Practice of Law, Section 6068. It is the duty of an attorney to do all of the following. And then we go to D, to employ, comma, for the purpose of maintaining the causes confided to him or her, those means only as are consistent with truth, comma, and never to seek to mislead the judge or any judicial officer by an artifice or false statement of fact or law. That's the key provision of the California Code that Mr. Eastman is accused of violating. And what the California Disciplinary Authority, it released its opinion. The State Bar Court of California, the Review Department, released an opinion last year on June 13, 2025. It's a 100-page opinion basically saying that Eastman violated Section 6068 of the California Code because he misled courts. And there are two courts. There's an intervention that he filed on behalf of the state of Texas and the United States Supreme Court. And then there's also a claim he filed in federal district court for the Northern District of Georgia. And what the State Bar of California has found is that Eastman knew or should have known that these statements, factual statements in these pleadings, were false. So let's just quote here the NDC, charge violations of Section 6068, Subdivision D, based on Eastman's actions in his intervention motion, count 2, and in the Kemp action, count 4. The Kemp action is a case against the state of Georgia, which narrowly went for Biden. Section 6068, Subdivision D, imposes a duty upon attorneys to not seek to mislead a judge, quote, by an artifice or false statement of fact or law. And they quote a case for that. There's a defense that you acted in good faith, and they quote the case for that. And then they quote this sentence from another case called Payne v. State Bar, quote, honesty in dealing with the courts is of paramount importance, and misleading a judge is, regardless of motives, a serious offense. Again, another quote, counsel should not forget they are officers of the court, and while it is their duty to protect and defend the interests of their clients, the obligation is equally imperative to aid the court in avoiding error and in determining the cause in accordance with justice and the established rules of practice, unquote. Furlong versus White, that's from 1921. And the key language here, Eastman conceded at trial that he had an obligation to verify the substance contained in his filings. Yet his testimony attempted to minimize the scope of his duty when pressured by time constraints or when he deemed something in the pleadings to be, quote, preliminary or setting the stage. Eastman was charged with knowing the assertions in the Texas complaint that there was, quote, rampant lawlessness arising out of defendant states' unconstitutional acts, and that, quote, taken together, these flaws affected an outcome determinative numbers of popular votes in a group of states that cast outcome determinative numbers of electoral votes were false and misleading. There is no contrary to Mr. Eastman's claims, there is no First Amendment protection for making false statements to a court. The entire legal system of discipline would crumble if a lawyer were allowed to make openly false statements or things that we know to be false to courts. And then the opinion goes on, and it's 103 pages long with evidence of some of Eastman's false statements. Upon our review of the record, sufficient evidence exists of Eastman's attempt to mislead the federal district court to support culpability for count 4. So they've clearly found that there were efforts to deceive multiple courts with false statements of fact. These are not protected statements under the First Amendment. This is not Mr. Eastman's opinion, and in my judgment and in my opinion, he was properly disbarred, and his disbarment will stick because his defense, his lawyer says he wants to appeal to the United States Supreme Court. That appeal will go nowhere, in my view, because you can't make false statements in pleadings, and the court can't put itself in a situation where it makes it legal for a lawyer to lie in a pleading and create some type of flaky First Amendment right to do that, because that would undermine the entire integrity of professional discipline. It would undermine really in some ways it could undermine other federal statutes, including potentially fraud statutes, lying to the government statutes. It would undermine an enormous number of law enforcement mechanisms of the U.S. government, and it shouldn't. Eastman has no basis for what he is claiming, that the First Amendment protects his right to file false pleadings. So, in my opinion, John Eastman was properly disbarred by the state of California. Thank you.